Hello, thank you for joining us today. My name is Brenda Price. I'm the Associate State Director for AARP in Michigan. We're so glad to have you join us today for this wonderful chat. We are going to talk about managing someone else's money. But before we do that, I'd like to do one housekeeping item. You are on Facebook and you can put questions in the comments section. We really want to hear your questions. So if you type them in during the presentation, when we take a break, I will read the questions and they will be answered. So that's all you have to do. Sit back and relax and listen to this wonderful presentation. I would like to introduce you to Latoya Hall. Ms. Hall is our guest speaker today. She is our expert. She is the research assistant and program director at the Institute of Gerontology at Wayne State University. Ms. Hall, we look forward to hearing your presentation. Thank you.
Thank you, Brenda. So I'd like to thank everyone for tuning in today to check out the presentation on managing someone else's money. As Brenda mentioned, I am from the Wayne State University Institute of Gerontology, and we have a program within the Institute called SAFE, Successful Aging Through Financial Empowerment, where we do a caregiver empowerment program to empower caregivers on the dynamics of managing the money of others. And that's what we're going to be talking about today. So I want to start off with just giving a few facts on informal caregiving. Informal caregiving is usually when there is a family member or a close friend or someone of that nature taking care of an older adult. It's usually unpaid. There are 34.2 million informal caregivers in the United States to older adult over 50. That was per AARP in 2015. In 2015, per AARP, 15.7 million of those informal caregivers in the U.S. were caring for someone with cognitive decline, Alzheimer's, or some other form of dementia. And then also, a Gallup poll in 2011 showed that caregivers usually spend around 13 hours per month managing the financial matters of other people. However, one thing that we do know with informal caregiving, that although there is a lot of work involved with being an informal caregivers usually receive no training on their role. Their financial management role, their assistance with healthcare, their homekeeping role, any of those roles, informal caregivers usually get no type of training for. So then there is when someone starts to become an informal caregiver and they get in and they notice that there's a problem. The person that they're caring for has a diminished capacity to handle their finances. They notice things that this person probably would have never mishandled financially before. They're starting to be mishandled. Things are starting to be forgotten or paid twice, or simple calculations are starting to be messed up and not made properly. Sometimes they just need another person to handle their money. And then those people who handle the money due to capacity issues We call those people fiduciaries, but we call them lay fiduciaries. So what lay means is that they're not professional fiduciaries. And when I say they're not professional, I want everyone to understand that even though they are not professionals, they are a critical source of help to older adults who need this type of help. They often have no training, and sometimes unknowingly, some of them commit fraud or commit money mishandling. And so we want to do these seminars and offer caregivers this support, because sometimes you can actually do something wrong without knowing it because you're not aware of the do's and don'ts in your role as fiduciary. These lay fiduciaries, as I mentioned before, are usually family members, friends, or other non-professional caregiver. Next slide. And so we want to talk about what is a fiduciary. So a fiduciary is just a fancy word for someone who has been named to manage money or property for someone else. So if you're ever named to be the person who's handling the money or the property or anything financial, you are the fiduciary for that person, okay? And as I said earlier, there are professional fiduciaries who do this for a living as professionals. A large sum of money is entrusted to them, but they're supposed to spend it in the interest of the person whose money it is. And then there are lay fiduciaries, which most of us are or will possibly be at some point, who has to come in and help someone manage their finances due to any type of cognitive or capacity issue. I think we are ready for our first round of questions, and then we'll come back and talk about the different types of fiduciaries.
Thank you. That's an interesting start to the conversation. One early question is, does the fiduciary have to be legally identified through the court like a guardian, or can they simply be a family member that has been chosen to be the fiduciary?
Yes to both. And so in my next slide, I'm going to go over the types of fiduciaries, because fiduciary is just a broad word for someone who's handling money. So each of those things mentioned are different types of fiduciaries, and I'll go over those in the next part of the presentation.
Okay, that sounds great. Thank you. Continue.
Okay, so there are different types of fiduciaries. And so this is kind of like the question. There are actually 4 different types that we're going to talk about right now. The first type of fiduciary that we're going to talk about, if you are named someone's agent under power of attorney, you are a fiduciary. I do make people aware that there are 2 different types of power of attorney. There's a durable power of attorney for finance, and there's a durable power of attorney for healthcare. That's another presentation and conversation. However, as a caregiver, you may want to look into having both of those, but the durable power of attorney for healthcare says that you make healthcare related decisions, and the durable power of attorney for finances says that you do the financial management thing. So you want to remember that. But that's a type of fiduciary, the agent under power of attorney. And that's usually going to be, as that question asks, the friend or family member or other loved one, that this person, when they were at a good capacity, was able to say, this is the person who I want to be my agent under power of attorney. So basically, the power of attorney is a legally binding document that gives you the authority to make decisions about someone else's money or property on their behalf. The person giving you the authority is called the principal. So the older adult is going to be the principal, and they're actually giving you authority to make decisions on their behalf. Under power of attorneys, I tell people that the older adults can still, even if you have a power of attorney, legally they can still manage their own money or property after they sign it. The issue is capacity. It's not just because they gave you a power of attorney, you get to handle everything, and they don't really get any say-so. They still get say-so under the power of attorney. A power of attorney can be changed or revoked. A power of attorney can... Yes, those are the 2 different types of power of attorneys. I'm sorry. The agent under power of attorney for healthcare and the agent under power of attorney for finances. So you want to be aware of both of those types of power of attorneys and make sure that you are getting what you need to be able to do what you need to do. Next slide, please. The next type of fiduciary is court-appointed guardians or conservators. The court-appointed guardian or conservator, this is from that question. It's usually someone that the court names to manage money and property for a formally competent adult who loses the ability to take care of him or herself, okay? In Michigan, there are court-appointed guardians and court-appointed conservators. Usually getting guardianship over someone says that it's kind of like the power of attorney for healthcare is. It says that you take care of their medical and living arrangement. And then conservators are the people, especially when there's a large sum of money involved in Michigan, who get appointed to take care of the property. Okay? In this process, you have to file a petition with the probate court. So you go to whatever probate court is in that county, you file a petition. There will be a hearing. As the petitioner, you have to notify the individual in person, and you also have to notify all interested parties. So if the person has, say, children living, other children than yourself, if you're a child, or if you're a sibling and they have children, you have to notify their siblings if they have any children, parents. They'll let you know at the probate court who needs to be notified as people of interest, but those are definitely parents, siblings, and children. The court is going to appoint a guardian ad litem in this process, and the older person is going to have an evaluation. They're going to be evaluated by the guardian ad litem. They're going to be evaluated for capacity and other things to see if they really need a guardian. You're also going to be evaluated as a person petitioning the court for guardianship. They're also going to evaluate you. There may be a few things. Sometimes if there is a large enough sum of money involved, they want you to be bonded, okay? I frequently tell people, don't be surprised if you go to court for guardian or conservatorship and the court deems that you're not a person who can properly handle that role and appoint someone else. That does happen, okay? The guardian or conservator has the duty to the older adult and the court. So their duty is to both the older adult and the court to make good on their end of the deal. The guardian or conservator is a legally binding court-appointed position, okay? The power of attorney is something that you get from the person, being the agent under power of attorney. That's something you get from the person before they lose capacity. When there's already a capacity issue, say someone is in late stage Alzheimer's or dementia, that's when they need to go. You need to go and start the guardianship or conservatorship process. And under this process, you'll have to, before you start, I think it's within 56 days of being issued your letters of authorities, you'll have to go and fill out an inventory. So you'll have to file an inventory with the court stating property, money, and everything that this person has that you'll be liable for managing. Okay. The next one that we're going to talk about is there are two different ones. So you can be a representative payee to Social Security, or you can be a VA fiduciary. And this is simply a person's designated by the government to manage income and benefits for a person who needs help managing their money. So a lot of people think that because they have the power of attorney or because they went to court and got the guardianship or conservatorship, that they're automatically able to deal with Social Security and the VA. And that's not necessarily true. The VA and Social Security will usually recognize you if you have been appointed by the court as guardian or conservator, but you're going to have to send them that paperwork and get things set up. And then usually if you're an agent under power of attorney, you're going to have to actually apply, and then they do a whole nother investigation to make sure that you are a person who is worthy of holding this position, okay? And in these things, unlike the power of attorney or some guardianships, you will not be able to get paid for serving as a VA fiduciary or Social Security payee. those roles come with the court of you having, those roles go with the territory of you being that person's caregiver and telling these entities that you are going to manage their money and do right by these people and their money. And so you cannot be paid. Under power of attorneys, there's a section where the older adult could write in that they wanted you to have payment and how much. And if you are thinking about getting paid under power of attorney, if that's something that you and older adult has agreed on, it's something that you definitely want to have them to write into that document, because you never want anyone coming saying that you did anything that was illegal and you being held liable for those things. Now, there are 4 basic rules that we talk about to being a fiduciary, okay? The first rule that I'm going to talk about is you should be acting only in the older person's best interest. Read your document and do specifically what it says. Try not to act outside of the confines of that document. If there's questions, it may be a question you want to ask someone at the probate court, but you need to be acting within the confines of that document. Understand when the document becomes effective. These things become effective at different times sometimes. Within power of attorney, durable power of attorney for finances, there is where it could be something that's effective immediately. It could be something that's what they call springing, that's only affected once there becomes a capacity issue or an active cognitive decline diagnosis or something of that nature. So you want to understand when this document becomes effective and when your duties go into play, because you don't want to overstep your role before your duties go into play, because you could be questioned for wrongdoing. Make sure you're not borrowing, loaning, or giving the older adults money to yourself or others. That's pretty self-explanatory. We talked about being paid. Avoid changing wills or estate plans that the older adult has made if you can. Now, if the older adult is adamant about wanting to change their will or estate plan, it's definitely something that could be done per them having an evaluation and saying they have the capacity to do so. So you should definitely follow their wishes and help them with the things that they want help with. But it's not something that you just want to change yourself. You want to stay away from that. Avoid conflicts of interest. Things like hiring family members to do work because your cousin has a business that does this type of work, but you could have gotten it 3 times cheaper and a better job from a local company hiring a local company to do the work. So you want to be really careful about making sure you're not tying up things for conflicts of interest, okay? The next thing we want to talk about in managing someone else's money is you want to be really careful about managing that person's money or property. You want to make sure that you list all of their property, money, and debts. That's going to be for guardianship or conservatorship. It's going to look something like that inventory that I talked about that you have to submit to the court in 56 days after accepting that appointment. Even though it's not a requirement for agent under power of attorney, it's something that I would suggest, because if anything ever comes up, you can always pull that out and say, this is what they had when I started. This is what they have now. This is what has happened in between. So you always want to be keeping a record, a good record. If you're responsible for investments, you want to make sure you watch that and invest their money carefully. You want to definitely make sure you're paying their bills and taxes on time. You do not want things going into foreclosures or defaults because you haven't paid bills properly. You may want to set up a payment schedule. Think about things like automatic payments from banks and things of that nature. You want to make sure you're collecting debts. You want to make sure that you make a budget. You want to make sure that you are protecting their property. You may need to use safe deposit boxes, and you want to definitely make sure that you have insurance up to date on everything. You want to keep their money and property separate from your own. So do not deposit their monies in your own or anyone else's accounts. Try not to do joint accounts. It's very important. A lot of people, when they get power of attorney or guardianship or something, they go out and do joint accounts. But you don't need to have a joint account to be able to exercise your right as power of attorney or guardian. I'm going to give some contact information in a minute And if you have questions about that, you can call me, but you don't need to do joint accounts for that. Keep all the titles to their money and property in their own names. Always sign documents as agent or conservator. Never sign with your name. Be sure to pay their expenses from their own account and not yours. Keep good records. Keep a good detailed list of all the money you spend or receive. Keep receipts, notes, even for small expenses. Try to avoid paying for things in cash. Usually plastic keeps a better record of spending because you're able to go back and look through transactions. Um, Again, about getting paid, we talked about that. File your accountings with the courts. If you're a conservator, you have to file accounting once a year, so make sure that you're filing it. If you're just the agent, even though you don't have to file anything with the courts, I would suggest doing these things just to have your own record, just in case someone should ever call something that you've done into question. File a final accounting after the older adult passes away. That's for conservators. And then Social Securities and VA fiduciaries must keep those agencies informed about the older adult and changes so that they can adjust benefits accordingly. And I think we're ready for a round of questions.
Oh, that was wonderful information, Latoya. There was a lot there. So I have a few questions. One, in Michigan, is it required that a spouse become a guardian for their spouse, or do all of those rules fly out of the window when you're married?
So what I found out the other day, interestingly enough, on a call with some attorneys that I work with here in Michigan, that even if you are married, you probably want to look into doing power of attorneys while you are both at a good capacity, especially if there's some blended family issues. Because people think that it automatically goes to the spouse. Well, that's not the case. Someone could get you in probate court and in a lot of red tape by going to file for guardianship or conservatorship or something before you do. So spouses, if that is your wish, you may want to, while you both are at a good capacity, do those documents and appoint each other as agents, because it's not necessarily a given that it's going to happen. And the attorney also informed me that the hospital, in cases of healthcare decisions, could take the spouse, if there's not a power of attorney or guardianship or something in place, could petition guardianship to the court over the spouse if there's a question in care. So you want to make sure, married or not, that you could even have that you have those documents, just as a backup plan.
Well, that's interesting. It basically sounds like you're saying people need to prepare well in advance, and that's one of the questions I have here is, when should people prepare? What's a good time? People don't tend to want to talk about these issues. So when would a person prepare?
So I am 41 years old. I have a will. I have an agent power of attorney for healthcare. I have an agent for power of attorney of finances. So it's not like when or what age. It's something, because I'll probably have to change those things as I age, but it's something that you want to do while you have capacity to do so. And so I tell a lot of people who are not guardians yet, but who are anticipating being guardians, like my mom and dad are in their early 60s, but right now I'm getting them to get those things together for themselves, because right now they have good capacity and good cognition, but you don't know what's going to happen. And so it's not something that you want to wait for. I say if it's something that you've thought about, you may want to go ahead and do it.
Makes sense. It does make a lot of sense to just be prepared and get it done. And the fact that you already have it done should help guide our audience, which is largely 50 plus, that they should get it done too. It's never too early. Some people are fearful about sharing their financial information. Do you have any recommendations as to how to get past that fear?
And so we talked about that in difficult conversations from the standpoint of being the caregiver and going to someone talking about, their finances. And so it's a way that the caregiver could approach to help that person get over that fear, not approaching to, it's like we did a whole video on it, but it's like not approaching too aggressively, going to that person and saying something like, have you thought, in the event that something happened and you couldn't do things for yourself, who you will want to do things like pay the bills around here, and how that would look, and don't ever be surprised if they say, yeah, I thought it was your sister and not you. But that's a way to approach the conversation. And if you're the person with fear, I would say, I don't know how to say get over it, but I can say a good strategy is really thinking about who you are thinking about being that person, and making sure it's someone who you feel good about as far as trust and relationship wise. And so if one son is a son who has stolen from bank accounts, and that may not be, even though you've forgiven them, you're past that, that may not be the child that's going to make you feel as secure being the agent as the one who has never had any history of those things. So a couple of things we say: try to avoid people with gambling issues, try to avoid people with credit issues, try to avoid people with drug addiction and alcohol addiction issues, try to avoid people who have been untrustworthy and have been found to lie a lot, and just be very deceitful. So it's not saying that they're all bad people, but it's saying you have to look for the person you can trust the most to make you feel better about disclosing things. And then you don't have to disclose everything. If you have an attorney or someone, a financial planner or someone that you trust, they can know about everything, which they probably already know about. And this person isn't to know about these things until then. I want it this way. You don't have to tell them where every single penny is. You do have to let that stuff be laid out somewhere for them to be able to find that information. But you don't have to sit down and go over where every single penny of your life savings is.
That's a very good point. If you do the proper documentation with legal counsel, they have a record of your wishes, and that does not have to be exposed until the time comes. That's a wonderful point, because I have another question here that says, how do people get organized in case that day comes? Should they have a list in the house where this is where you find the bills, this is where you find the accounts, or this is where you find my attorney that you need to reach out to? So is there some structure that you recommend that people get in place?
I think those are great ideas. And if you keep those lists and things, if you keep them in a safe deposit box and say, look, I'm the only one with the key. Here's the key to the safe deposit box. Something happened, here's where it is. And then all of those things are in the box, or there's no lockbox in your home. If this should happen, this is, where everything is that you'll need to know. I have my aunt, she doesn't have all of my stuff, but she is, I'm lost for words. She is the executor on my will.
Yes. Okay.
And so she knows if something happens, everything is here on this shelf in the back in this color box, So it's those are all great ideas. I don't have a single strategy. I say, you don't have to disclose, again, you don't have to disclose everything at that point, but let that person know where they can find everything that they need to find should you not be able to direct them.
Okay, well, that's all of our questions. You answered everything beautifully. The presentation had great information that is relevant. You also noted about having difficult conversations. And for the audience, Latoya conducted a video on having difficult conversations a few weeks ago, and that is on our Facebook page. So you can go back and watch a prior presentation that she did on difficult conversations. Thank you, Latoya.
So just a few more things, closing up. We have no cost one-on-one assistance for caregivers anywhere in Michigan who would like to receive assistance in obtaining the necessary legal documents, if they need support with proper record keeping, filling out consumer complaints or police reports if they detect them or the person that they're providing care for has been the victim of any type of fraud, pulling and reviewing credit reports for themselves and the person that they provide care for, assistance with preparing budgets, coaching and support on difficult conversation, and financial coaching services for caregivers' personal financial issues, and more. Anything, any type of thing that you need assistance with as far as caregiving and managing someone else's money, we are here to support you, free for no cost. This is my contact information, no cost, safe coaching services. Right now, we're offering the services over Zoom and telephone due to the COVID-19 crisis. You can contact me at, my name is Latoya Hall. The telephone number that you can contact me at is 313-664-2608. 313-664-2608. Or you can just email me at l.hall@wayne.edu. Thank you.
Thank you, Latoya. Again, that information is wonderful. I've been a caregiver. I've had issues in families, in my own family, with how we manage all of what you detailed here, fiduciary arrangements. So to the audience, I would say, if you haven't had the experience, or even if you have, I would say review this video again so that you are very clear on some of the steps that you might have to take in the future. And reach out to Latoya. The fact that she and Wayne State offer this valuable service to the community is just wonderful, that you can actually get some one-on-one coaching from her. We thank you for being present today and taking time out of your day. If you want more information about what AARP in Michigan is doing, you can please visit our website. It is posted here. And you can also come to our Facebook page. Our website is aarp.org/MI. Please get online and see what we're doing. We're doing a lot. Thank you very much. Thank you, Latoya.
Thank you.